You are watching the third annual Omaha Bar Association Bench Bar Briefing. I'm Dave Summers, Executive Director of the Omaha Bar Association. This event was held on Thursday, August 12th, 2021 at the 1901 Howard Modus Building. For those of you who have not checked out our podcast, you can look at the Modus Building, which has been redeveloped by an OBA member for attorneys and other nonprofits to be housed in the location. It's a very, very cool redevelopment of the space, and we are very thankful for them allowing us to hold the event here today. The schedule for today's bench bar has 6 judges speaking for approximately 20 minutes in length. Due to time overruns, this CLE has been approved for 2 hours and 15 minutes of CLE credit in both Nebraska and Iowa for on-demand credit. To receive your credit, please email dave@omahabarassociation.com and I will make sure your credit is reported. CLE credit is free for 2021 OBA members and is $50 for those who are not members. We will have Judge Stephanie Hansen, the Omaha Bar Association president, speaking first for Douglas County Court, and then Judge Rossiter from U.S. District Court, followed by Judge Hutton from Sarpy County Court, and then Judge Keeler from Douglas County Separate Juvenile Court, followed by Judge Rettelsdorf of the Douglas County District Court, and finally, Judge Arterburn from the Nebraska Court of Appeals. Thanks so much and enjoy the third annual OBA Bench Bar. I will note that we cut in just about a minute and a half after Judge Hansen starts speaking due to some technical difficulties. I apologize about that.
We do have limited resources in county court because, again, it's kind of a lightning round. So we don't have the luxury of a lot of time. So that is helpful when you're getting ready to come into court, making sure you have your ducks in a row and you're ready to go, have your exhibits ready to go, maybe have a sticker on them already. We don't have someone to do that for us. So the judges, we do it ourselves. We sticker our stuff, we keep track of our exhibits ourselves. So it is really helpful if practitioners, when you come to county court, you try to help us out the best that you can. If you have any proposed orders or anything else, it's nice to have those right away. So if we're, for example, you're going to do an adoption, before we start the hearing, bring up the proposed order, bring up your exhibits. If you need something marked, we can get those all done right before we go on the record, and then it makes the record much more smooth as we go along. And that same principle applies whether it's a civil case or a criminal case, a probate case, things like that. Another thing to know about Douglas County Court is it's 12 different islands of fun. So 12 different judges. So there's not a lot of uniformity necessarily in rules or the way that court is run. So it's really great to use these types of opportunities in bar associations or things like that to find out, well, what do you know about how Judge Hansen does things versus how Judge Kime does things versus how Judge Lowe does things. And I think you'll hear a lot of different things, and that helps you prepare yourself and prepare your client for what it is that you're going to get, because it could be very different in different courtrooms. Some people are real sticklers for procedure and rules, and some people have kind of their own procedures and rules, and that's just honest. So talk to some of your colleagues about some of those things as well, about what you need to know. I think that some of the other, one of my pet peeves for what it's worth is I don't like sitting there all by myself waiting for somebody to come in. So if you're going to be late, that's totally fine. I totally understand. And most judges do if you're bouncing between different courtrooms. But when you sit till, you sit for a half an hour waiting and no one comes in, and then you get a call saying, well, you never heard my case. No one was there. Well, give me a heads up that you're going to be late. And then I know, as opposed to you're just not going to come. So just, common courtesy. Would you want that courtesy? probably. So we like that courtesy as well. So email the bailiff or send a note with someone if you're going to be late, especially if you're going to be pretty late. Trying to think of what else I was going to say. Judge Keim always suggests, and this is in the notes from last year, is to have little cheat sheets on different types of cases in different courtrooms. And I think that's a really good idea. I'll pick on a couple of the people at this table that I used to practice in front of. You get to know people's tells, and like when you've said too much, maybe when you haven't said enough, and following some of that body language. And so it's getting to know, but that's the practice of law, is getting to know how something's going to be in front of a different judge. While the law is the same in every courtroom, the way you practice might be a little different. The way you prepare your client might be a little different. And so, keep a little cheat sheet of maybe when the tops of Judge Hutton's ears get a little red, you might want to back off. Or, if Judge Arterburn starts to flare his nostrils, that's probably not a good idea either. And Judge Zestera's mustache used to be kind of the litmus test. It was kind of like flying a plane. You got to keep it steady. If it starts going down, it's not a good plan. So, but we're just people. So think about those different tells and what it is that you see, kind of like reading a jury or reading anything else like that. But, talk to different people who practice in there, what people expect. I'm probably too fast here. All right, Dave, do we have ready for questions? I don't really have anything else to say about county court. That's a good question. In probate, he asked if there's a way to accelerate special administratorship proceedings, because sometimes it can take a long time to get a hearing in probate court in Douglas County. Did I fairly state your question? Okay. Especially the special administratorship when you want to file a personal injury case as well. So wondering how we can get that going a little quicker. And that, I think that it judge dependent. If you, like, for example, if you had me, I would be more than happy to set a WebEx hearing on like a civil motion day. So I do those every other week. So it'd be pretty easy to do that. You just have to figure out which judge would do it. Sometimes the judge who's on duty might do it that day for probate duty, but that would, I would say probably try either the duty judge if you need it really quickly, or whoever it's assigned to, see if you can get it put on a non-probate day, since they're generally just an administrative type of record. If you don't know that, it's the audible eye roll. That's what I got. Judge Rossiter, they have more rules.
And if judges want to ask each other questions, that's always good too.
All right, I'm Bob Rossiter. I'm actually the new chief judge of the United States District Court here. I shouldn't be, because Judge Gerard promised me a year ago that if I would take this on, that COVID would be done. He lied to me. So I want to talk about what we do, what we have done for purposes of COVID, how our courts are operating, and then I'll get into some other issues here. I will tell you that no significant changes, as I come in as chief, no significant changes are contemplated. In terms of COVID protocols, we've been reacting. I want to actually thank the folks on all the Douglas County courts, because when things were at their worst, they included us in a lot of discussions with county health officials and the like. So you can rest assured that all of us had all of the information that we could have to make you, the jurors, and any of your clients safe. We have, as you enter our courthouse, you should take a look at our website. We're on, I don't know what number general order we're on, but it's 2021.07. And what we've done in this general order basically is to have a little more flexibility based upon the level of community transmission, rather than putting out a general order every time things shift. What it says now is all persons in any federal courthouse in Nebraska, including fully vaccinated persons, shall wear a face mask in public spaces in the courthouse when that transmission is substantial or high based upon the CDC COVID data tracker. What we've done is our clerk's office staff has different signs, and you'll know when you come in the building what level we're at and what is expected of you. Persons who are not fully vaccinated shall continue to wear a face mask in public spaces regardless of the level of community transmission. There's some other things in there, but in terms of individual judges, paragraph 6 of it says nothing in the general order shall prevent the presiding judge in a court proceeding from directing or permitting the use or removal of face coverings by participants in that proceeding. So it's going to be left up, at least at this point, to each individual judge as to how they're going to handle COVID in their courtroom. Last year, we did put together subcommittees of our court in civil and criminal trials. We shut down like everybody else did in early 2020, resumed jury trials for a few months in 2020, and then shut them down until February of last year. We have been holding jury trials ever since. I've had 6 or 7 jury trials, I think, since that time. The other judges have as well. They've gone pretty well. We have utilized Zoom hearings or WebEx hearings, especially. The difference between state and federal court at this point is before the CARES Act, we were not allowed to at least handle changes of pleas and sentencings. We are do that. We are doing that now. We were doing that less. Really on a case. Judges are still doing via Zoom and WebEx. The good news is we are in a position, at least most federal districts that I've talked to, we're about pre-COVID. In other words, if you want a trial, you can probably get it. On the criminal side and the civil side. Judge Bisher and Judge Gerard have had a couple of trials in the last couple of months. So we are getting to the point, I won't say caught up, we're back to where we usually are. On the other side of the coin, our numbers in civil and criminal cases, especially criminal cases, because the grand juries are more active, are going up. So we're going to see a spike in the criminal cases. Juries, we've seen no significant reluctance to serve due to COVID. We've had some people that have opted out before they've gotten there. But in terms of talking to jurors during voir dire, amazingly, we haven't had anybody that has said, I just can't sit here. I'm scared of COVID. Trial processes, voir dire, we have, at the worst, when we started back up in February, we started doing voir dire in 2 separate courtrooms. So we had to do it twice, which was a pain with criminal juries. We're now back at least to 1 courtroom, and I think the judges have agreed that at least for purpose of voir dire, since we have everybody in that courtroom somewhat spaced, that wearing a mask. And I'm sure folks have run into this, especially on the criminal side. The real challenge of the masks is being able, in picking a jury, and I understand that, being able to see the reactions of jurors. A great example of where it was problematic is a bank robbery trial that I recently had, where make them take down their masks. So there's just a lot of challenges that we haven't had to deal with before. We don't currently ask about vaccination. Personally, what I do with jurors, because what we've been doing with jurors is, if you're fully vaccinated, you can sit in the box unmasked. I don't know where that's going to fall my next trial, but I have simply, is my expectation that if you are not vaccinated, continue to wear the question, and put that also in with, if you are uncomfortable with being in here, vaccinated or not, you can wear a mask. So you're really not, but you aren't calling out the person that, thank you, calling out the person who is unvaccinated. Local rules, we've been trying to downsize local rules where the federal rule will suffice. I would invite you, we're always open, and we receive every year suggestions for local rule changes. We have a committee, and Judge Bisher chairs that looks through those every year and looks through our rules to try to streamline them. A couple of new ones are fairly new that you may not be aware of. Historically, our district, when I was practicing, went through the no page limits, let's do page limits, and then the judges were dealing with requests to exceed page limits, more motions for that than anything else, so they did away with page limits. We've gone back to, and it's consistent with the circuit, we've gone to a word limit, because everybody knows how to use that particular function, and if you don't, Terry, there's somebody at your office that can tell you how to use it. I'm the same way. I don't know how to do it. But we think it's enough. I think it's 13,000 words for an opening brief. And unless it's end of the universe type of case, that probably should suffice. We are certainly open to requests for good cause shown for exceeding those limits. Judgment, when we talk about common mistakes and tips and the local rules as well, always take a look at Rule 7.1, which is the motion, general motion rule, but also Rule 56.1. Where I see the problems is, and I know some think it's a pain, but we think it's applied across the country, is doing the pinpoint citations. That if you're going to make a motion for summary judgment, what you need to do is first of all, not argue in those fact paragraphs, just set forth the facts, set forth where we can find them, and do links to them, and put each thought or each fact in a separate paragraph. And when you're answering those, what the rule says, a short numbered paragraphs, when respond to each of those paragraphs with your own pinpoint citations. Try to avoid arguing in that. One of the biggest problems I see is you get the pinpoint citation that is anti to what was raised by the movement, and then you've got all sorts of argument within that paragraph. Admit or deny it, and move on, and we will look through those things. Other common mistakes and tips. The word processing that all of us have is great. But what I'm seeing more and more of is cutting and pasting. And there's nothing wrong with cutting and pasting as long as you're going back and looking at what you've cut and pasted is appropriate. I regularly get briefs that it's a female plaintiff and she is referred to as he throughout. And other circumstances where names are referred to in there that obviously came from a different brief. So take the time to proofread or have someone else proofread for you. I see a lot of that. If you need more time, ask. We have rules as to when the responses should be made. A lot of times those blow by, and I've got to enter an order, that a show cause order why the motion shouldn't be granted because you've blown by the date. Keep track of those things. And I think most of the judges, if you said, okay, even press of business or anything else, I can't get it done for the following reason, and you don't need to give me 5 pages of reasons. You can give me a sentence in reason, or even it went to the bottom of my pile and I didn't realize it. Ask for the time. You're going to get the time to answer. Just don't ignore orders or rules. Our magistrate judges do a great job. They do a great job on the civil side in progressing cases. They are open to talking to you at any phase in the case. If it's a case that you believe should be handled by the district judge, it's kind of out of the ordinary, but I've done it. You can ask. But generally speaking, I think our magistrate judges do a great job in progressing the cases. Keep in mind, and it's not in the local rules, I think this is a great thing. All of our magistrate judges in their civil case management practices that are on our website, they require, everyone knows in discovery disputes, one of the things our rules require is that you make a meaningful attempt to not just send an email, but make a meaningful attempt to meet and confer about discovery issues. What the magistrate judges have also required, and I think this has been, everyone I've talked to says it's helpful, is before you can file any type of motion to compel, you need to contact the magistrate judge who's assigned to it and informally talk to them about it, so that you don't spend the time. Now, they're going to make you put together a little bit of a summary, and it's not a long summary of what the issues are, but you can handle it in an informal way without going through the formal motion to compel. And I will tell you that most of the times, there are some issues that are left hanging that have to be dealt with a motion, but most of the times, most of that is taken care of. So be aware of that, not only that it's available, but number two, that it's required before you file any kind of discovery motion. Settlement conferences. We've got some great mediators in this part of the state. But we also have 3 magistrate judges who very much enjoy doing and are willing to do settlement conferences. Take advantage of that. They've done some of the settlement conferences. I think Judge Nelson has done, and Judge Wart, I think all 3 of them have done settlement conferences via Zoom and find it, at the beginning, they found it not as bad as they thought. And in recently talking to Judge Nelson, he indicated that he thinks he's going to do a lot of them that way in the future, because Zoom gives him the opportunity to put people in rooms much the same as you would do in a mediation. So I think that's very effective. Our magistrate judges have been very effective in doing that, and not to take the work away from any mediator. There's no cost to it. And I always found when I practiced, especially if I had a difficult client, that it always helped to have somebody that wears a robe for a living to tell your client or to tell the other side that here's where your problem areas are, that was helpful in getting matters settled. So I think that's been very effective, and that's available to any of you at your request. And then I guess finally, I want to talk about consent trials with our magistrate judges. We've got three, actually four. Judge Gossett is on recall status. We've got four magistrate judges who are good trial judges in their own right, and have been good trial practitioners. You still have the ability, and for one reason or other, our district has developed different than other districts. There are some districts where consent trials are done all the time. There are some districts like ours where nobody consents to it. When a case is originally assigned in our court, what happens is it can be assigned originally to a magistrate judge or to an Article III judge and a magistrate judge. One of the reasons it's assigned and may be assigned to the magistrate judge is to encourage people to at least think about consent trials to that magistrate judge. Most people opt out of that, and you can do that pre-trial fairly early on. But I guess I would ask you, especially if it's something that you want to get tried more quickly, and even though I say we're caught up, you are always in my court subject to any criminal trials that are coming up. So you can get a date certain, usually with a magistrate judge. So I guess that's my final point, is to keep that in mind, that you can consent to a trial before our magistrate judges. And I know Judge Kimes tell only because I practiced in front of her, but she's a neighbor of mine, and I can even tell that as a neighbor. So she's never annoyed with me, it's other neighbors. Any questions? Yes. All right. Absolutely. Actually, I think that the question was, it really started out with the difference between state district court and county court and federal court in terms of oral argument or getting a hearing. Ours has developed into paper practice a lot, and dispositive motions especially. If you want a hearing, I don't grant it a lot, but when somebody is adamant about it, I have usually granted it. But tell me the reason. If you're just going to repeat what's in your brief, I don't need to hear that. But if you think that it's especially a particularly maybe complex matter, that it would help to have some direction and funneling of issues, let us know that. Some judges are less inclined to do it. I've done it. I won't tell you that I do it once a week, but I have done it in the past, and I'm open to being asked, and the rules allow that. Any other questions? There is, the question was, given the fact that civil cases always take a back door to at least those criminal cases that need to be tried for speedy trial purposes. If you've got a date, a trial date with a judge, is that going to go on that date? I will tell you what I started doing, and it doesn't mean that something wouldn't get moved, but I've done what Judge Smithcamp did, and I still have what I call a civil week. Now, I will tell you, Joe, I haven't had a civil trial, and part of it's COVID, for 2.5 years. I mean, I've had a lot of criminal trials, but the civil trials, not because they were in line behind criminal, but because they've been resolved, because the magistrate judges have done such a good job in settling them. But generally speaking, I try to keep to those dates. Now, there are other things that happen. And we try and give it enough notice. Like I've got one this fall that I had to move a month because I've got to go to chief judge training somewhere. And I didn't know about that. So that was the last possible one of those. So I had to move it. But I try and honor those dates as much as I can, and try and keep those civil weeks so that we've tried at least to schedule the criminal cases around that in the other 3 weeks of the month. Now, some of the other judges don't do most of the other judges, I think I'm the only one now that does a civil week. I suppose it depends on the question was, would I expect the other judges on the court to follow that and to give precedence to a civil case that had been set for a while. I think quite honestly, it depends on the type of the case. I mean, if it's a 2-week products liability case where everybody's been lined up for it, the chances are that the judge is going to do everything that they can, or I certainly would, to make sure that that's tried when it's set. If we're talking about a 3-day diversity automobile accident case, I know that's important to you, but probably not so much. And it would depend on the witness, where the witnesses are coming from and things like that. But if there are issues that come up with that in terms of getting people scheduled and those types of things, raise it with the judge, raise it with me. I mean, I've had criminal cases that we've been able to move for speedy trial purposes because this is the only time, the expert witness is going to be in France for 8 weeks and we can't get it done any other time. The alternative is to move it to next year. Well, we'll do everything we can to get that, keep that on that particular date. Yeah. Anyone else? All right, thank you.
Okay, thank you. Thank you for including me from Sarpy County Court to participate in this panel discussion today. I'm going to go through some of the materials that you had mentioned had been areas that would be of interest to you, I think, as probably practitioners that have been in Douglas, certainly, and in Sarpy County for many years, but also those of you who may be younger or newer to the practice of law. A couple of highlights I think that I'd like to start with first is, if you haven't seen it yet, the Nebraska Supreme Court through the Chief Justice did issue a new COVID-related administrative order on Monday of this week. And I believe if you go to the Nebraska Supreme Court website, you will see that order there. And in that order, it reads very similar to the orders that have been issued in the past, but what it does do, or what it adds, is a recommendation that each of the courts, district courts, develop a plan for their particular court. So in this case, I know that Sarpy County District Court, on behalf of the court in Sarpy County, has submitted a plan for any new restrictions or anticipation of how court operations might be affected going forward, should there be any changes with regard to the frequency of the COVID virus. In Sarpy County, we do have a lot of technology that has been put in place over the last year and a half. We've been very fortunate that Sarpy County, as a county, has funded a great deal of this technology being put into each of our trial courts. So I think you will find access via WebEx and via Zoom available to you in each of our courts. And so in that regard, I wanted to touch just on sort of this new reality that we have of promoting more online hearings and such. One of the concerns that the courts have had is how some of these hearings are going to be conducted, and do we need to have any type of decorum rules or anything associated with that. And you might find of interest, and I'd encourage you to go to the Lancaster, Lincoln, Nebraska. Lancaster County has posted Zoom participation rules. As far as I know, this is the only county that has produced these type of rules or published them. And I know that the court there has been involved in developing these rules, but I wouldn't be surprised if you see these types of rules be ones that will be duplicated in other areas. Obviously, I'm not in a position here to see those of you who are appearing via Zoom right now, but I can assure you that no one here is in violation of these rules at this time. But these are things that were generated because of actual experiences that have happened in the courtrooms in Lancaster County, I know for sure. And that is such limitations of appropriate clothing that need to be worn. If non-attorneys are appearing via Zoom or WebEx, certainly we would expect attorneys to comply with the same, but there are clothing now requirements where you are not to wear clothing that has profane or inappropriate language on it, symbols or ideas, or simply the lack of clothing will not be tolerated for courtroom proceedings. The other thing is that you're to limit the profile pictures that you may have that come up when you are appearing via Zoom or WebEx, that those pictures as well, you should be clothed in those photos if you're going to appear in a court proceeding. Another thing too is that I know has come up is that you're not to appear in court while in bed, because that has been a concern of something that has occurred again in court. As well, other restrictions would be you're not to smoke, eat, drink, watch television, listen to music, or engage in other distracting or inappropriate conduct while in the Zoom courtroom. So I share these things with you, obviously for a couple of reasons, but one of which is, as attorneys, obviously you're going to need to have some guidance as to what you think courts will or will not tolerate or can tolerate with regard to your clients or witnesses that may be appearing via video. So take this into consideration and look this up as a rule. And I think it's a nice guidepost, if you will, of maybe a conversation that you might want to have with your client or potential witnesses if they're going to appear. If you are going to appear or you do want to have a hearing via WebEx, in Sarpy County, you're going to need to file a written request for that to be heard. When you do file the written request, recognize that it's going to have to be processed by our staff. So again, don't wait until the last minute to make such a request. Our preference would be is that you file it at least 48 hours before a hearing would have already been scheduled. Also, when you do send the request, recognize that our staff then will send you as the attorney the link to sign into. We're not going to be sending that link to your client. It's going to go to you, and then you need to forward that to your client if your client is going to be appearing or participating in the hearing. Also, if you're involved in any criminal proceeding and you're wanting your client to appear via they're in custody someplace, again, we're going to need that advance notice at least 2 days in advance, because almost all of, if not all of our correctional facilities in Nebraska and certainly in other states are doing the same thing that we are. They're scheduling multiple hearings all day long, and we have to fit within their calendar. So we may not be able to accommodate a particular exact time when a case is going to be heard. So again, keep that in mind. If you are going to request a telephonic hearing for any reason, you cannot, at least in Sarpy County, call into the courtroom. We're going to have to call you. So if you do make that request, put the telephone number in your request as to for how we can reach out to you. And again, recognize we may not be able to call you right at 1:30 because of the other hearings that would be scheduled in advance as well. And then certainly, lastly, don't assume that any request that you make to appear via telephone or appear via WebEx, that is automatically granted. If you haven't heard anything that affirmatively states that this has been granted and this has been scheduled, then you need to plan to appear actually in the courtroom. And this sort of dovetails then into the issue just of continuances in general. Obviously, in the court system, we get a lot of requests for continuances. We would like to have you place those on file again at least 3 days before the hearing is scheduled. When you file such a written motion, if you'll include in the motion, if you've communicated with the other side, and if this might be a stipulated agreement to continue the matter, because if we don't know that you have made that affirmative representation, then chances are it's going to stay on the calendar, and we'll hear the motion to continue at the time of when the case was originally scheduled. Again, don't assume that the case was continued simply because the motion to continue was filed. Again, it takes time for that motion to get from being filed to the judge. I know now with the justice system, you can file your motions 24 hours a day, 7 days a week. But again, if it's filed at 8 in the morning for a 9 o'clock hearing, chances are the judge is not going to get in front of the judge in time to respond to it and reschedule something, even if it might have been a stipulated agreement to continue the matter. Another point would be is if you do file a motion to continue, don't just pick your own date as the date that the parties have agreed for the next hearing, because we need to be there too. We need to make certain that we have space for your case to be heard at that time. Another thing I wanted to bring to your attention is that the Nebraska Supreme Court did approve in July of this year what has been described as new modernization rules that are going to take effect January 1 of 2022. These are extensive rules that change a number of things with regard to how pleadings are going to be filed, how briefs are going to be filed. In essence, it's modernizing our process to go even more paperless, if you will, with regard to the way we're going to be conducting hearings. So again, I refer you to the Nebraska Supreme Court website. It takes effect January 1, so please familiarize yourself with that. And I don't know if the Bar Association might be doing any type of programming in anticipation of it, but it is going to have some significant changes to how we operate. Do's and don'ts, I guess I would just touch on, I think what Judge Hanson had touched on and Judge Rossiter, and that is, each of our courtrooms does have a bit of a different culture. And I think it is a good idea to become familiar with what the particular environment is, if you will, in each courtroom, to know how best to practice law, if you will, within that courtroom. And if you're a younger attorney and you haven't been in a lot of the different courtrooms, I certainly would encourage you to come and watch court, visit the courtrooms. If you have witnesses, other parties that are unfamiliar with a courtroom setting, have them come to the courtroom and just watch proceedings just to get comfortable with what is certainly a foreign environment to the vast majority of people that are appearing in our courtrooms, in particular in county court. Emails. Don't send an email directly to a judge. That can be considered an ex parte communication. You're going to need to, first of all, what I would do is reach out to the clerk's office or reach out to the judge's bailiff and find out what type of communication is permissible with regard to a particular case. Because part of the problem that we run into not only is an email going directly to a judge, that would be ex parte communication, but even if there's two lawyers involved, let's say in probate matters, a lot of times there is a non-represented person that's involved. Well, they may be left out of the loop if just the lawyers are sending that communication to the judge. So that's why we have to be very careful to make certain that that communication is transparent and that everyone is in the loop and not just communication between the judge and the attorneys. If you're practicing in county court, chances are you're moving around from courtroom to courtroom to courtroom. In Sarpy County, we are scheduling like hearings in each of our 3 county courtrooms at the same time. Excuse me, at the same time. Just for your benefit and for our benefit, if you need to be in more than one place at a time, we don't expect you to be able to accomplish that, at least not effectively. So let us know if you stop in, say, my courtroom. I need to be in courtroom number 2 at the same time. Just to let you know, I'll be here, as soon as I can get here. And it's the same thing with a lot of the attorneys here that practice in Douglas County. You also practice in Sarpy. Let us know if you have a conflict so we can try to help accommodate you, traveling between Sarpy and Douglas County. I think Judge Hanson touched on this. If you have exhibits, go ahead and pre-mark the exhibits. Don't put a number on them, but go ahead and you can pre-mark the exhibits and then just bring them with you. If you do so, though, if you're going to intend on bringing exhibits, again, in county court, a lot of times the person or parties on the other side are not represented. Bring copies of the exhibits so that you can share those copies with the other party. If you can, bring a courtesy copy for the court so the court can follow along if you're going through a particular detailed exhibit. As I think everyone knows that certainly would be an attorney, but you would share with your client, and that is we simply can't have thumb drives or some sort of technology that would be similar to that marked as an exhibit and offered into court because of course, with viruses and things such as this, we need to have those things pre-screened, or scanned to make certain there isn't a virus. And we run into that complication a lot on small claims actions and some of these things where someone will come in with a phone and just say, here's my phone, you can watch the video, or here's a thumb drive. So keep that in mind that if you're talking to your clients. Our courtrooms in Sarpy County, and I believe that everyone in Douglas County now is this way as well, are well mic'd. So anticipate that we are using a recording system. And so if you're talking to your clients and things such as this, just recognize that the tape recorder is playing. So keep that in mind that you're going to, you do run some risk that your conversation can be heard. So again, keep that in mind as you're communicating with your clients. An obvious don't would be don't just miss court. We know that sometimes you're again scheduled in 2 different courts at the same time. But if you are, tied up in one court, let us know. Contact our clerk's office and get word to us as to what the conflict is that has come up. Another matter that we seem to have a lot of is requests for expedited hearings. And this can come up with our probate, temporary guardianships and conservatorships, certainly protection orders, things such as this. In essence, short settings. Again, keep in mind that a lot of times when you may not, say, be in court or something and you wonder why, well, why can't this case be heard tomorrow or the day after or whatever? We are backfilling frequently our calendar with short settings of things such as protection orders or temporary guardianships or things that have these real tight deadlines that we need to fill in. Next, let's see. On my notes here, there was a question with regard to zealous representation or abuse of your responsibilities, I guess, as an attorney. I think a lot of it just comes down to, again, just communication in general, and that is to keep open communication with those that you're litigating against. So that we don't get into these situations where there's an allegation that something was scheduled or something happened that the other party didn't get notice of. The biggest obstacle that we run into always is making certain that everyone knows about a hearing in advance so that they have an opportunity then to be heard. The last thing I think I'll share is just a pitch, if you will. I know that a lot of you work in a variety of areas, of course, of the practice of law. Myself and many other judges have become very involved with in our probate area in particular, and guardianships and conservatorships. If you're in a law firm and you're in a position where you would have the ability to serve as a guardian ad litem in a guardianship case or in a probate case, we really need the members of the bar to help us in this area, because we simply have a number of people who need that representation. And we have the ability to get that representation to them to look out for their best interests when they're an attorney and can be appointed. There is a training requirement that goes along with this. I would encourage you again to look into that on the Nebraska Supreme Court website and the Attorney Services website to get that training, and please sign up to be a guardian ad litem in these cases. Every attorney that I have spoken to that has become a guardian ad litem has found it very rewarding because you're actually using your skills to help people that otherwise would not be represented. As far as attorney's fees are concerned, when you do make an application for any attorney fee, obviously we are going to need evidence in support of that application for attorney fee. So do prepare an affidavit if you are making an application for that, so we have evidence of it. And then lastly, I would encourage you to, again, in the guardianship and conservatorship probate area, to go to the Office of Public Guardian website. They have a lot of valuable information on training for guardians. They have a lot of valuable information with regard to what the process is and the responsibilities are of our Office of Public Guardian, which is currently representing roughly 300 people as their public guardian. I would encourage you to join, if you haven't, the Inns of Court. I know I was a member for many years, found it invaluable to be able to sit with judges and with attorneys and learn a great deal about, again, sort of that culture of the practice of law and the different courtrooms. And then also the Bar Foundation in Lincoln. Reach out to Doris Huffman there. And if you can become involved in any of the activities that they have with the teen court or with the high school mock trial program, I know that you become role models for our youngsters in high schools, and it really it's really, I think, a rewarding process for everyone that does get involved in that. So those are my comments. If anyone has any questions. Yeah, sure. The question was that if you make a request to appear via video, you have to justify or make an explanation as to why. I don't think that we haven't required that there be a specific request, but just recognize that under the rules, if it's a contested hearing or an evidentiary hearing, that there may be a circumstance where under the rules that the other side may have to agree to it. And if they don't agree to it, then we're going to have the parties in person. We have tried to be as flexible as possible, given the pandemic, of allowing people to appear as much as possible via WebEx and via Zoom. And like I said, we're fortunate to have a lot of the technology now to do that. Any other questions? Well, the question was, can some of the people appear via Zoom and some appear in person? I guess my response is it depends. I think it would probably just depend on what the circumstances are, because we certainly do have cases where I think a lot of it depends on, is it a contested hearing? And if we're going to have evidence that's produced, then we run into the problem where I think we're going to have the people appear in court unless the parties would agree otherwise. But any other question? Anything online?
What's the better court? Sarpy Court or Douglas County?
I didn't hear the question. The question was, which is better, the Sarpy County Court or the Douglas County Court? Is that the question? I think our 93 county courts around the state of Nebraska are the best county courts in the United States.
There are no questions online. I'll just say a few things before we go to break here. Thank you. Thank you to the three judges who have spoken so far. For those online, please email me to let me know that you're watching for CLE credit. We have cookies. If you know anybody who would like to watch this for credit, it's free for OBA members. 2 hours, and it's going to be available on demand for the next 2 years. So spread the word. We're happy to get as many people out to watch this live and on demand. So we are in our second hour, 20 minutes approximately per judge, and then we'll be done. And anybody who wants to go on a tour, go down to the third level and we'll get a tour lined up. So I'm going to turn it over to Judge Keeler, with Joe Bradley peppering questions in the front row.
I noticed that Joe moved to the front row in the break, so that's great. It's good to see you, Joe. I'm Matt Keeler with the Juvenile Court in Douglas County. First of all, I want to talk about what we've been doing for the last year and a half and what we are doing moving forward. Juvenile Court's different than any of the other courts that you have represented here today in that we don't have jury trials. And so when the pandemic hit, that was one of the major obstacles for the rest of the judges on this panel today, but we didn't have to deal with that. We were able to keep going for the most part with Zoom hearings. And as we move forward, the vast majority of our courtrooms will be doing that for the foreseeable future. And for many hearings, that might be the case even after this pandemic is over. Part of that is, what we found is that for some of the kids and families that we handle in juvenile court on a daily basis, it's worked much better for them. And again, it's a different group of people that we have than you see in the other courts generally. So, for example, for kids that are charged with crimes, we call those delinquencies, we have dedicated hearing times in juvenile court for each case. So it's not a cattle call, it's maybe hearings every 15 minutes for kids. And so we're able to dedicate that time. And so for a kid right now that has a hearing with one of us, instead of coming down to court for half a day or missing school for half a day to come down and see us, the schools have been very good about accommodating those kids and letting them use a conference room, using a counselor's office, the principal's office, to call in for those hearings. Same thing with the parents that we have. Sometimes we're setting hearings 3-6 months ahead of time, but in many cases we have emergency hearings. And so there's not a lot of warning for parents about when they have to come to court. And, you know, many of the parents that we have involved in juvenile court, or they have kids involved in juvenile court, they don't have the kind of jobs that any of us in this room have, where we have flexibility to go take care of whatever needs to be done. They may have to take off a whole day of work just to come down for a 5, 10, or 15-minute hearing. So another advantage that we found for the population that we serve at juvenile court is that a lot of parents have been calling in to hearings in their work uniform, in their cars, you know, that sort of thing. We're seeing a lot of that. So well, we've had, now Judge Hutton mentioned, you know, people in bed. We've had a lot of shirtless people, all men so far for me, but it's a lot of shirtless people. You see kids once in a while that are in bed for the hearing, and the parents waking them up for court, which that kind of tells you where the problem is right there in many cases. But we've been able to keep moving forward with that. We've allowed a lot of hybrid hearings too, which sometimes attorneys are already in the building. We have a lot of practitioners that practice in different levels, in county, district, federal, and juvenile. So they may be in court for one judge in person, and my hearing might be by Zoom, but we allow them to come in. They've set us up with these fancy screens now that allow us to hear what's going on in Zoom. They're large screen TVs, and we can see what's going on in the courtroom. So that's been nice to make that work. And it has, for the most part, there are issues with technology, like I'm sure everyone's experienced in this room, every judge has experienced, but for the most part, I would say 95% of the issues we've had with Zoom are attorney related. They're not parent or kid related, because let's be honest, the kids know how to do that stuff better than we do. The attorneys, I haven't had any cat filters, but I've had basically everything else you can have with attorneys having trouble getting in there. Now, we have, every day we hold detention hearings up in juvenile court for kids that have been arrested maybe the day or a day or two before. And with the start of the pandemic last March, we started doing those by video. That will continue, I think, for the foreseeable future as well. We've been lucky to have a defense bar and the county attorney's office to work with that I think agreed in general that video detention hearings have worked. Part of that is because the detention laws have changed over the last couple of years. So it is a very narrow group of individuals that can be detained as a juvenile under the current law, which I'm sure you read complaints about that in the paper and Facebook and whatnot, but that is the truth. The law has changed, whether you like it or not. So the number of kids being detained is restricted. So by the time we get to that detention hearing, it's usually pretty black and white on what's going on there, which again has made it so that Zoom is more convenient to have those hearings as well. So in any case, that's been a major part of what we've been doing. We do have, since last March, we've been having trials still in person, evidentiary hearings in person, contested matters, motions to revoke, termination of parental rights trials. We were able to keep moving through those to not let our docket get too backed up and keep those in person. There have been cases where we have attorneys, some are appearing by video and some are in person. And as long as there are no objections to that, we've moved forward with that as well. Part of the reason for that, one of the major complaints that I've always heard about juvenile court is that there are too many attorneys involved in each case. And it's true. In a criminal case, you may have just a prosecutor, a defense attorney, and a defendant, and that's it, besides the judge. In juvenile court, you're going to have, if there are two parents, the parents, each of them have an attorney. They may each have a guardian ad litem if there are mental health issues. We have a prosecutor. We have a guardian ad litem for the child or children. We have an attorney for the Department of Health and Human Services. We may have intervening grandparents that have an attorney. So you could have 7 or 8 attorneys easily in a hearing. So even in the last year when we've had these in-court trials, we've been spacing people out to keep them socially distant. But there's only so much you can do with that many parties involved. We had to have some people appear by video even to get through some of those hearings. But we were lucky to be able to keep up on our docket, which has worked out well for us over the last year. We did just, I think today, with the Supreme Court order that came out on Monday, we did update our operations plan. There are nuances between some of the courtrooms. I think everyone on this panel would agree it's hard to get any group of judges to agree on really anything. But so there are differences between the courtrooms, but the vast majority are proceeding the same way we have really for the last year and a half. So the next question we were asked to cover was some of the do and don'ts of practice in our court, in the juvenile court for me. The number one thing to me, and I think this carries again for every court, is, it's already been said to a certain degree, is knowing your judge, knowing each nuance of every judge, their likes and dislikes. I think that's 95% of practice, frankly. I mean, whether it's county court, district court, federal court, I mean, they all have rules you have to abide by, obviously a lot of procedure there. But for those of you that represent clients, I was a defense attorney for about 11 years. I was a prosecutor before that. But as a defense attorney, it was so important to be familiar with the courtroom and know the protocol. I think Judge Hutton suggested watching courtrooms to get familiar with the protocol, whether it's the level of court, federal, juvenile, county, or whether it's the particular judge, because when you come in there and you're unfamiliar with the protocol or what that judge likes, dislikes, the judge is obviously going to pick up on that. The other attorneys are going to see that, but most importantly, your client will see that too, and see that you don't have any relationship with the other parties, with the judge. And when you're retained, that's not a good look for a client if they can tell that they may have hired the wrong person because you don't know what you're doing in that courtroom. So it's good to get an idea of that ahead of time. The number one misconception I want to address in juvenile court is that I always hear that the rules of evidence don't apply in juvenile court, and that's not true. There are, just like any other level of court, there are hearings where different rules apply, or the application of the rules of evidence is different. But for example, if a child gets arrested for a delinquency, for a criminal offense, that the rules of evidence apply just like any other court, with the exception of the fact we do not have jury trials, even if a child's charged with murder, for example. We do have kids, unfortunately, that come up on those charges as well. The second thing I want to address, the relationship. I already talked about the relationship with the court, being familiar. But one of the first things that Judge Daniels, who's another judge in the juvenile court, told me when I was appointed is that you can see from the bench what the relationship is between an attorney and their client too. And that is true. And so what I mean by that is you can see when there's tension between an attorney and their client, but more importantly is you can see whether or not there's been communication there as well. It's abundantly clear as soon as you see what's going on there. And sometimes, again, I've represented people for a long time. I'm not naive, and I understand sometimes clients are going to come in, they want to get rid of an attorney, and it could be lying. 100% of what they say is a lie, and I understand that happens. So you can have attorneys that have done everything they can do, but those clients are still going to come in and try to throw them under the bus. That happens. I think all of us are able to decipher which times those are accurate and which times they're not accurate. But when you see a pattern of conduct for an attorney where you have several clients coming in over time that say, I can't get a hold of my attorney, they never call me back, whatever, you start to lose your credibility with the court. And it's harder to give the lawyer that the benefit of the doubt when you have seen over a period of time that the client after client comes in making the same complaint. So staying in contact with your client, I realize that it is difficult in practice to do that at times with everything everyone is juggling. It's especially difficult when I was in jury trials. It was the hardest thing in my practice because you felt like you were neglecting every other case and every other client you had, and they especially felt like you were neglecting them, each time. You have to remember that every time somebody hires a lawyer, no matter what kind of case it is, to that person is probably the most significant thing that's ever happened in their life. Even if we know, for example, a first offense DUI, in the scheme of things, it's not that big a deal to maybe anybody in this room or any judge. To that person, it might be just devastating to even be charged, to have to go to court, to have to go in front of a judge, to go in a courtroom, to any of that. So to each client, no matter if we know where they fall in the pecking order or the level of importance, the client doesn't see it that way at all. So in any case, that's important. I think Judge Hutton touched on this too, but the clothing thing with Zoom, that's something that I didn't have to deal with as a private practitioner, but teaching, just like I would tell clients in certain courtrooms, this is how you should behave and don't talk unless they speak, those kind of things, general things. We do see crazy stuff on Zoom. We see, like I mentioned, the shirtless people. We see, I've always said, I don't know where they sell sweatshirts that say world's greatest dad or world's greatest mom or hashtag mom life or hashtag dad life. But wherever they sell those, their clientele are the people we see in court. I see more of those in court. Like somehow that's going to influence what we do, but we see those all the time. But the truth is, again, it is important. It's no different than the impression we give somebody sitting in front of us. If they're coming in not dressed appropriately on Zoom or in bed or any other scenario, it has the same effect of coming in and wearing something inappropriate in the courtroom itself. One issue that we see in juvenile court, especially, that I want to address is, I'm already going over my time, I think. Real quick, for child witnesses and adult witnesses too, the importance of prepping, whether you're a defense or a prosecution, prepping those witnesses. We have a lot of young attorneys that we deal with in juvenile court. And right out of law school, I was right out of law school when I started in juvenile court. And child witnesses, it's a very nuanced type of direct and cross-examination. And the best attorneys that we see are able to cross-examine kids, for example, and make their points without being aggressive towards kids. It doesn't always work. They can make their points without being a jerk to children and without the kids even realizing 99% of the time. It's very hard to do and it takes practice. But on the other side, if you're a prosecutor or a civil attorney that's going to call a child to testify in any matter, you need to prep that child because it's nerve-wracking for an adult to testify. Imagine if you're a child testifying, how difficult that may be. And I don't care if they're 6 years old, 10, 15, 18, whatever. It's very stressful to do that. And they need additional prep time. Police officers, they can read the reports. They know how to testify. They're trained to do that. Kids are not. And you can tell right away when a kid gets on the stand or in chambers, if it's in chambers testimony, you can tell right away when they haven't been prepped. And that's terrifying for a judge to see because, especially in my neck of the woods where they may be testifying against their parents, if they're not prepped properly, that could be a disaster. So I think I'm over my time. I think that's it, unless there are questions. Joe, yes. So the question was that the fact is the filings went down in juvenile court during the pandemic across the board. So the question is, have we seen those start to go back up? And if not, what plans, does the bench have any plans to try to help put those children in protective situations? The difficult part is, it's about the filings, first of all. They've started to come back up. Part of the reason we attribute the lack or the decrease in filings to is children, a lot of children were doing remote learning in the past year. They were in the homes. They didn't have access to some of the people that they would normally disclose any sort of abuse to. So teachers, other students, counselors at school, people at church, that sort of thing. So I think there was a problem with that as far as kids having access to people that they could talk to. I think that we've seen some of the filings go back up now that kids, we'll see them start to go up as kids start to go back to school here this week, next week. We also had no truancies filed. So truancy when kids are skipping school, I think we went about 8 or 9 months without a truancy filed at one point. So, and I think the schools didn't know what to do with that last year because kids had a real hard time. How do you keep track of remote learning attendance versus in person? So I think we'll see a turnaround this year with some of those kids coming back in. As far as, there are a number of reasons. I could be up here for hours talking about why we have fewer neglect cases filed. There are issues involving federal funding and initiatives for states to avoid kids being made state wards. And we could talk about that forever. But the bottom line is that we can't help as a judge, as a court, kids that we don't know exist. So those kids don't come into our world unless a police officer or a doctor or a child protective safety worker files an affidavit saying these kids need to be in our care. So it is scary because there are, I think, families out there that we should have in our court at times, but we don't know about them unless somebody has assessed it as a situation that warrants coming before court. So I wish there was something more we could do on that, but that's above my pay grade. It deals with department stuff. So, okay. Yes. Yep.
This is a question my wife asked.
Uh-oh.
How is the master program working for you? And do you have a dog?
Do I have a dog? There are no dogs in Douglas County Juvenile Court. That's a previous era. Yeah, we have cats now. No, we don't have any animals. So we have Judge Brown. That's as close as we get. So the other question. I'm sorry. Forgot it.
CASA.
Oh, CASA. Okay, so CASA. Right. Yeah. The question was, how is the CASA program doing? So the CASA program, the court appointed special advocates for children. They're volunteers that volunteer their time to work with kids that have been pulled from their homes that we have in juvenile court. It's a wonderful program. They have, we swear in new CASAs, I think once a month. So it's a growing program. I think it's been tough for them for the last year and a half because, like anything else, they haven't been able to go into homes necessarily and see kids and build that relationship like they were before. So I think that's something that will improve too over the next few months. I hope. It feels like we're taking a step back right now, but they do wonderful work, and it's always good to have somebody involved in a situation that doesn't have an agenda, whether it's financial, legislative, whatever, statistical agenda. They are just there. Their only job, they're not getting paid, is to assess the situation and hold people accountable if they're not doing it. So it's a great program, and I think every courtroom is using it. Every juvenile court's using it throughout the state, as far as I'm aware. Yes. Anything else? Okay, I'm going to pass this to Judge Rettelsdorf here.
Okay, Don, if I'm putting you to sleep, wave your hand. All right. Hi, everyone. I am really glad to see you all. I would not have thought last July that I would come to a group of lawyers in person and be so excited to see everybody, but I am, and it's really great. So the first thing I did when I heard about what we were supposed to talk about from Dave is I went to the boss and I asked Renita, my bailiff, what things make her mad, because when she's mad, I'm mad. And so I thought I'll start with some practical tips from the bailiff and the court reporter. You might think I'm kidding, but I'm not. When she's frustrated, I know it, and I know exactly who she's frustrated at. I know exactly what they said that made her mad. I know when they said it. So just keep that in mind. One of the things, I'll just give you a couple of those things. This is a consistent problem. Lawyers, I know it's hard to get quick hearing dates, and it is particularly now. But lawyers will call up. Well, first of all, if you're having your secretary call or assistant call to set a hearing date, make sure he or she knows how long that hearing is going to take. It is like the police officer that stops the drunk driver. How many beers did you have? Were you drinking? Yes, I had 2 beers, no matter what. How much time do you need? 15 minutes. Because all the lawyers think, well, I'm going to get in faster. And then they file their motion for this 15-minute hearing. And then what they do, or what drives Renita crazy, is they slip in other motions. Well, I've got this hearing time. And so when she gives me the file, I'm frustrated because there's 15 minutes and now there's 4 motions filed. Don't do that. Practical tip, call up and say, can we fit another motion in? Because you're going to prep, you're going to get ready. I'm not going to be happy. I know who filed the motions. It's just really, as we set those hearings for the length of time that you tell us to set the hearing. So you get the first step of control, but if you abuse it, then it becomes frustrating. All right. Let's see what else she said here. Oh, and same when you cancel things. Or when you find out it's not going to be contested. A perfect example is motions to compel. I'll get a motion to compel that someone says takes 15 minutes. And by the time they get there, they've settled it. Well, it is helpful. I know it might only be set for 15 to 30 minutes, but I can do something else. I can start something else. If I didn't have something before that, I can fit something in. So as soon as you know it's not going to be contested, let us know. People will call up and they'll say, can I have a couple hearing dates? And I'll get a hold of my co-counsel and I'll see when he or she can have that. And then I'll let you know. Then they file their motion with that hearing date. But that's one of the problems with e-filing. We don't get a copy of that. All right. So she'll give you those two. You don't call back. You're not on the calendar. So remember, if you say, can you give me a couple, be sure you either send her a copy of your motion, email her a copy of your motion, or call back and let her know. That happens all the time. And so we'll have empty spots that we could have filled. Again, she writes, please advise me if you need additional time for a contested hearing. There's a recent court rule change, 10-page ruling. Is everyone aware of that? If you're going to fax something in to the court, this is especially something I think domestic attorneys fax more stuff into the court with affidavits and things in temporary hearings. There's a 10-page limit. Okay, that does not mean 3 emails with 10 pages for a 30-page document. Okay, that means a 10-page limit. It doesn't matter if you have 10 one-pagers or 1 10-pager. You can do it either way, but 10-page limit. Let's see. A lot of people get hearing dates. We put you down and you don't file the motion. But we don't know that because you don't tell us. Let's see. Then the court reporter. For those of you who do criminal law, it's difficult when we know you're coming in for a plea, but the plea is supposed to start at 9 o'clock and you show up at 9 o'clock and give us what the plea is and she has to do a probation order. Okay, from my court reporter, she struggles when people don't comply with their exhibits and letters to the court. I don't want, and I'm going to talk in a minute about court reporters, but I don't want to lose my court reporter. She's very valuable, but on the night before a trial, we really are doing other things the day before your trial. And so if you get, when she gets at 4:30 the night before the trial, all your exhibits, she's frustrated at me because I don't always hold lawyers accountable to the time schedule I set out. So either you can stop doing that so Lori's not frustrated, or I could start holding you absolutely accountable. But there are very few lawyers that follow those timeframes exactly. And I also don't want to punish clients. I want to be careful with that. But it's very important. It's important that you pay attention. All you have to do if you need extra time is send an email to counsel, to co-counsel, and to the court. I'll grant extra time. You know, we can work around that. But if she's sitting there, I can't tell you how many times my court reporter or my bailiff has to email attorneys in the 2 days before trial. And yes, domestic attorneys, I'm primarily pointing at you. And asking, are you going to trial? I don't have any exhibits yet, those kinds of things. And it's okay. You know, I get how I did a couple trials in my life and I get how you prep for trials, but let everyone know what we're doing, because I need to know, am I going to sit and have a whole day of nothing to do if you're not having it? Anyway, try to comply with those timelines. Lori says, it's your record, you're making it, speak loud and clear and do not interrupt. Makes sense, okay. And then Renita adds one more time. Well, this is because it happens a lot. The bailiffs are giving you, unless you've really made them mad at some previous time, the bailiffs are probably giving you the first available date for the time frame you have. You would probably be surprised at how many times the bailiff will give a date and she'll get a call back about half an hour later from a secretary or the assistant that literally says, my attorney wants a better date. Okay, so just recognize that, especially after COVID, she really is trying to give you the soonest date that you have. And I think one of the other judges indicated, I think it was Todd, that we have a lot of things that are time sensitive. Ex partes have to be in within a certain time. Juvenile court transfer hearings have to be held within a certain time, TROs. So we can't always have everything booked from front to back. Okay. That was what they said. A couple things now just from me and sort of my thoughts. We have a lot of new judges. By October on the Douglas County bench, we'll have 5 new judges. And we'll have 17. Judge Engelman has been on the bench 2.5 months and has had zero applications for court reporter. Okay. The state of Nebraska does not pay near what the state of Iowa does. We've lost 2 court reporters in the last 9 months to the state of Iowa, and there are 2 additional openings coming up in Pottawatomie County in the fall. So right now we have 2 judges that don't have court reporters. Judge Stratman's court reporter is shortly leaving to go to Iowa, and Judge Engelman literally has had 0 applications. So if you want input on that, you know, the Supreme Court passed a rule recently, despite the objections from all district court judges. They passed a rule, and I understand, you know, this is not one side versus the other, because there are no available court reporters. We're short on court reporters. But there's going to be electronic and digital recording coming to a courtroom near you. I would say that probably the majority of the Douglas County bench will have some sort of electronic court reporting in their courtrooms, maybe by the end of the year. We have, again, the 17th judge and 2 additional judges coming on board probably by the end of October. And we can't fill those court reporter positions. So if you want to have input into those kinds of things, Judge Masteller has a committee of attorneys, court reporters, and judges, and they're working through that. They're trying to figure out how we're going to manage this and what we're going to do. The most recent caseload study found that Douglas County, this is including our 17th judge, to keep us equal with case numbers throughout the state, we would need another 3 additional judges. We need 21, and at that time we had 16. So we can't have judges that can't conduct hearings because they don't have a court reporter. We just can't do it. So if you're interested in being involved in that, and you want some input to that, talk to Judge Masteller. He's in charge of that. Okay. One of the new changes, Judge Hutton mentioned the modernization. Is everyone aware that your briefs will be filed, or to be filed in the court file starting in January? Okay, your briefs will be filed. So that leads into my next statement, I guess. Demeanor in the courtroom is what you say and how you say it. And just like you would a witness, and Judge Keeler touched on this, but just like you would judge a witness's credibility by their demeanor, it's a listed factor in the jury instructions. Judges will judge your credibility by your demeanor. It's just sort of, I guess it's just human nature to do that. And so it's something that you have to be aware of. But also your demeanor and your writing is important, especially since they're going to be filed. You know, you can say counsels and judges, it's hard to read aggressive briefs. You know, when they're condescending and aggressive, that's not what I want a brief for. But you can say other counsel's argument might be unsupported. I've had people say, unconscionable, outrageous. I wrote some ridiculous, and even calling other counsel's argument reptilian. I tend to ignore that then. I tend to say, all right, we're going down a path here that's not going to help me much. So I'd say it's just as important to not be overly aggressive in your briefs. And, you know, we're in the age of Twitter and Facebook, where, especially Twitter, where you can be aggressive and anonymous. Well, you can't be aggressive and anonymous in briefs anymore because the Supreme Court's going to see. So I think that's kind of a practical thing to look at. Know what e-filing is great, but remember, if you want something brought to the attention of the judge, you need to also just shoot them a copy of it too, because we don't get what you e-file. Okay, I don't get that. That doesn't happen. People e-file orders with their motions. Sometimes I get them, sometimes I don't. All right, so just be aware of when you're e-filing something, I don't always get a copy of that. So if it's something you want me to see before the hearing, make sure that you, I'll have Renita pull, or I'll pull up on Justice the motions if I have time, you know, the day before, but just make sure that you realize that orders aren't sent to us. Your motions sometimes aren't if you've chosen a date. When I'm saying too about demeanor, again, and I'm not picking on domestic lawyers, although I would say domestic lawyers were picked on horribly during COVID. You guys have been beat up because you were the only cases that got called in time after time after time. So you guys got beat up, and I think a lot of us recognize it. But when you're doing affidavits and your clients are doing affidavits, honestly, I'm more interested in your client's work schedule. And half the time lawyers show up and they don't know their client's work schedule because just the practical things aren't often included in the information that's passed on to me. Just the common sense, practical things I need. Everybody is really good at the mudslinging and those kinds of things, but practical things that I need to make those quick temporary decisions are oftentimes overlooked. So I think that's important. How am I doing on time? Let's see what else I have here. We are not in the same position when Joe asked the question of Judge Rossiter. We are not in the same position where we're catching up with trials. And I know I've said this to some of you who have appeared. I feel like an air traffic controller with trials. There's a bunch of them circling up there, and getting them to land is tricky. I have jury trials backed up at least 2 deep through the summer of 2022. So, and with the civil trials especially, I can set a civil trial, but no one ever wants to be backed up in a civil trial. It's really difficult to get civil attorneys, and I get the reason why. I mean, there's experts involved in all kinds of things if it's going to trial, but I also know you can't settle until you get a trial date. You really have to have that. So it's a balance between my schedule and your need. I know you got to get discovery done, and I know you got to have a trial date because then people will work to settle. So a little flexibility on availability is helpful. And if you have a trial that you don't need a ton of notice on, a civil trial, and you want to get it in, let the bailiff know that. I am willing to back up something. I need a week notice or something, but I'm willing to do that because my expert's in town and available. And you'll have a better chance of scoring a decent date and being called. Again, and I mentioned this a little bit about demeanor, but it is difficult as a lawyer. Well, it's difficult as a judge too, but to accept criticism, whether it's justified or not justified, without being able to respond. All I would say is carefully weigh the need to respond. I think that lawyers are much more worried about judges' response to what other lawyers are saying they did, or most of the time that I tune that out and I look for the neutral place to land. So just carefully weigh the need to respond, if that makes sense. Because oftentimes it may offend you, or you may think somebody's being personal, and the judge is going to think this or something. Most of the time, I don't think judges are weighing that or deciding that. As an attorney, we all run back to our office and we talk about, after we say how dumb the judge was, we start talking about what a jerk the other counsel was. And okay, that's fine, but I don't need to see that you think someone is that way. If they have been outrageous, or if they have gotten crazy, you don't need to respond. It's not worth it. It takes us off track and it wastes your time. I'll finish up here. This is just kind of two little nuggets, I think. It is a game. It is a stage play. It's a game, what we do, but it really is a game of skill. And so enjoy being a lawyer. I think over this last 10 months, maybe it's just taken a little bit of the joy out of it. So enjoy being a lawyer. And if you work hard and you prep hard, you will not find any other way to get that intellectual satisfaction that you can get from that. So don't let the last year, beat you down. And really, I think, try to enjoy it, because it's really a great profession. And that's all I have. Okay, that I can tell you the question was, if everyone didn't hear, if you're waiting on a motion to be ruled on, what's the most respectful way to ask a judge, where the heck's my ruling? And of course, that kind of goes back to the judge, right? There's some judges I wouldn't ask why they're sitting on something. They scare me. I'm not asking them that. But I think your bailiff might be the way in. But I think it's important to note that if I have something under advisement and it is 90 days past me taking it under advisement, I have to self-report to the Supreme Court. Every month I have to send in a report as to whether I have something that's 90 days overdue, or 90 days since that. So you might be able to remind the bailiff that, I checked and it's more than 90 days, Now, if you're expecting it to be in, of course, remember the bailiff's going to tell the judge what you said. So, use your best. I don't know. I think in my 13 years, I've had one time I had to report a case over 90 days. I don't know what other judges do. So I'm not very good. I think that I'm quick. I think I am. I don't know. But because maybe it's because my memory is not good enough to remember 3 months down the road. If I don't pick it up for 3 months, I won't even remember what happened. So I have to do it right away so that I have some clue what happened. But that's a really good question, and it's a really crummy answer from me. But I honestly think that it is part of your job to go try to remind a judge or try to ask. And sometimes it's just, and these guys could probably, sometimes it's just a nice ask. Sometimes the judge might have, it might be on the bottom of a stack or something. But I think it is, I wouldn't take it personal, because I think it is your job. Maybe after 60 to 90 days, I think it is your job to ask, is there a time schedule? Can I expect it at a certain time? You're asking me how you can do that without making someone angry at you. I don't know, but I do think it's your job to do that. So, yep. Anybody else, any questions? Yes. he asked, is there any guidance I can give to people waiting for civil trials in terms of how to get them in or get backed up? If you have something, for instance, in my courtroom, and it's a civil case, and it's not, and you really only need 2 weeks to get prepared, talk to the bailiff, say, I can go in November, December, give them 2 or 3 options, and make sure co-counsel before you call in can do that too. And all you have to do is let me know that you are okay being backed up to something else, or being backed up to another civil trial. In Douglas County, of course, those criminal trials take a precedent, because of the 6-month rule. But I think we've gotten some. Or the other option is, if you and I know, again, as I said, you're not going to settle something oftentimes until you get that trial date. So if you're willing, say, okay, give me something next March. I'll bet if you think at least you have a date, but just let us know if you're willing to back up to something, because it's most of the time there's not that affinity for that option. Anything else? Okay, thank you. I don't know, I'm making Dave giggle. Every time I do this, I make him laugh.
Well, it is a pleasure to be here. Since I went on the Court of Appeals 4 years ago from the district court, one of the unfortunate things about that is obviously I just don't see people nearly as much. The job is quite isolating in many ways. And so I sit back in my office at the north end of the Sarpy County Courthouse and nobody knows I'm there. So what's that? Yeah. So at any rate, it's good to see you all and see a lot of familiar faces. And I see quite a few smiles, but I think that's probably because I'm last. So I'll take it that way. I do have a few things to share with you today with regard to appellate court work. And one thing that I see and have seen since I've been on the Court of Appeals is something that's just very natural, and that is that most attorneys don't spend a whole lot of time doing appellate work. And because of that, they can sometimes fall into some traps and miss things that can be fatal to their appeal. Our Supreme Court is very tight with its rules. And if you don't follow the rules, you may, before you even get your brief filed, you may find that your case has been dismissed for lack of jurisdiction or something of that nature. Or your argument's not heard because you didn't assign error properly. And so it's very important if you don't do a lot of appellate work to have somebody else take a look at what you're doing that does do a fair amount of appellate work if you can, and make sure that you've got your I's dotted and your T's crossed. In that regard, the Supreme Court has adopted a whole raft of new appellate court rules that go into effect on January 1st. And I've got them here. And I would encourage you, if you do appellate work at all, to spend some time with these rules. And I'm told you can find this on the Supreme Court website. I did not find it, but I did know who to call and give me a link so I could find it. So I got it. But the rules that with the underlines for the new rules and the cross-outs of the old rules is really helpful. And I would encourage you to try to look those up and utilize those because there are a number of changes. I'm going to talk about a few of the changes, but we'd be here a long time if I did all of them. And I know how riveting that is, but I'm not going to do that. But just a few things that I want to say about that. First of all, of course, electronic filing has been here for a while, but everything is going electronic January 1st. You do not have the option not to, anything you do, whether it's filing a brief or motion, everything is electronic. Matter of fact, we won't get paper bills of exception anymore. The bills of exception will be strictly electronic, including the exhibits, something I'm not looking forward to when I have 1,000 pages of exhibits to try to parse through to look at something, but those will all be electronic. As far as your briefs, briefs now must be in a converted PDF form. They cannot be scanned. There are rules. I was interested to hear Judge Roster talk about the links. There are rules now. You can put links in your brief. So we can click on your citation and look right at the case as we're looking through the brief. Page limits are gone. Word limits come into effect. And you have, again, as the federal courts have done, a certificate that has to go on the end of your brief that tells us the words you that's brief. It's the word limits. When you do a request for transcript, you cannot just say, do a transcript of all the proceedings that happened in this case. You have to specifically ask for each document that you want to be included in the transcript. So if you miss something and what you're relying on isn't in front of us, then we have no record to review, and that could be a real problem for you. Conversely, if you're the appellee and you see, well, there's some important things that are not in that request for transcript, you can request a supplemental transcript so that everything gets in front of us that you think needs to be in front of us. Attention. There's the Supreme Court is definitely wanting to tighten up getting briefs in quicker and not granting extensions quite as easily. So make sure you read those. The rules differ whether your case is an advanced case or a non. For those of you domestic lawyers, if it's involved in custody, it's so you've got to have exceptional cause to have an extension of your brief. If it's home, then it's not an advanced case. And so then it's a little bit more lenient. The other thing is many of you may be familiar with the 10-day default letter. If you don't get your brief in on time, clerk's office sends you a 10-day default letter. You either need to have the brief in within that 10 days or in that amount of time. That isn't changing, but what is changing is if you do that the second time, don't expect a 10-day default letter. So if you've had an extension, or if you've gotten into that 10-day default period once, and lawyers count on that 10 days. A lot of lawyers, I can tell you, just, oh, I got another 10 days really here. That second time around, you may find your appeal dismissed during that 10-day period, thinking you still have that extra 10 days. So those are the kinds of things that are really getting tightened up. Again, there's a lot more changes in here. I'm not going to go through the rest of them, but you really need to be familiar with all those changes. One of the changes that's a little bit different in light is how you deal with the situation we've all dealt with when I was in practice, when I've been on the bench. How do you cite or when can you cite a court of appeal, a non-published court of appeals opinion? And we all kind of hem-haw around, well, I know we really can't cite this, but the Court of Appeals said, and in a case that's right on point, published opinion. Well, the rule has changed, and so now non-published Court of Appeals opinions may be cited only if the opinion has persuasive value on a material issue and no published opinion on the Court of Appeals or another court would serve as well, or when such case is related, and it goes on. So point is, you now can cite an unpublished Court of Appeals opinion, but you need to make sure there's not an opinion from the Supreme Court or a published opinion of the Court of Appeals that is equally as good. Then when you cite it, you need to make sure you're citing it and letting that it is an unpublished opinion. So they still don't technically have precedential value, but they can be used for persuasive value, just as an out-of-state case could. So that is a change. One change that one area of mistakes being made cross appeals. If you are cross appealing, you need to look at the rule very carefully, because your brief has to, on the cover page, say that there's also a brief on cross appeal. But when your brief is really two briefs. You have your brief that's in response to the appellant, and then you have you start over, and then you have your cross appellant's brief. And so that is something people just tend to miss a lot. And so the cross appeal isn't considered if it's not in proper form. Now, one change, and this change actually went into effect in May. If you first of all, under the rules, the first person to file a notice of appeal is the appellant. The second person to file an appeal is considered an appellee. That's why they have to show it as a cross appeal. But if your issue as the second one to file, if you have nothing that's adverse to the appellant, and you just file an appellant's brief, it would still be a better idea to follow the rules as far as a cross appeal. But if you don't, the court does now can say, well, since there's no adverse issues. And I can tell you where this came up was in termination of parental rights cases. And this is why the rule was changed, because we'd get mom being the first to file. Mom and dad's parental rights are terminated. Mom would be the first to file. Dad would then file his notice of appeal and just file an appellant's brief. Well, they have nothing adverse to each other. They have no adverse interests. But if dad just filed a strict appellant's brief, it would get kicked. And so that's a constitutional right. Parental rights are being lost because the attorney didn't file their brief right. And that came up in our meetings, and we said that's too harsh of a result. We've got to change the rule. And that's really what the impetus of the rule was so that we weren't having such a harsh result in cases such as that. But obviously that could come up in a multi-party case as well. With respect to briefs, this is on the prior list, but we see it over and over again, so I'm going to bring it up. There has to be a separate assignment of errors section that assigns your errors, and then a separate in the arguments. Just a heading on their argument, and then we're looking at it for plain error. And again, that's interesting for me as I've appellate country. Some states state. Our Supreme Court has said you got to follow these rules. So make sure that you do assign thing, you know, and you don't want to boil it down too far, just saying, well, the district court was wrong, you know, but you have to talk about it, but look at them and see if everything, you know, if you need all of those things, or if you're really saying the same thing several times. The briefs are, for most cases, the first thing we look at, whether you're the author judge or you're on the panel. And so the brief is extremely important, and I would encourage you to, you know, have a colleague or somebody look over your brief that maybe doesn't know that much about the case, because that's the first thing we look at. We don't know anything about the case until we start reading the briefs. Sometimes we read the briefs and we wonder, is this the same case? You know, the facts are so different. So you know, we all have facts that are adverse to our client. Don't ignore those things, because we are going to get to all the facts, you know, but when we read the record, when we read the other brief, I don't know, when you're talking about the malicious and that kind of thing, I don't know that we really get a lot of that that's one thing that we do see, is people just completely leaving out major issues or major factual things. And it's better just to take it on, okay, you know, and then deal with it. Try to work your way through it. Prioritize. I mean, there are limits, and there still will be an ability to file a motion to extend the number of words you can use, but really prioritize your best arguments, because there's limited space. Attorney fee requests. If you do have the type of case that you can request fees, make sure you give us a complete affidavit that shows what you did, how you spent your time, and so forth. If we just get something that says, I spent 25 hours on this appeal and my fee is $250 an hour, that's not going to work. We need to have your fee requests itemized. Finally, I'll talk just a little about oral arguments. 10 minutes isn't much time when you get in front of us. And the first thing I want to say actually is oral argument is important. In our court, maybe 1 in 10 cases gets oral. Some of that's because certain kinds of cases by court rule don't have oral argument, but still a small percentage of the cases that come in front of us that could be argued are actually argued. And so if you get on the call, there's a reason why you're on the call, because there's an issue or there's something about the case that we think is important to hear more about. So you need to, you know, so don't walk in thinking, well, it's a done deal. They're going to do whatever they're going to reason. And I can certainly tell you that decided the case the other way. Again, prioritize your arguments. First of all, you don't need to spend little, if any, time on the facts. Sometimes people just start going back to the facts. Well, and by the time oral argument, we've got a good grip on what the facts are. So get right into your arguments. And I think the most effective in a few arguments, pick out the 2 or 3 that are the very most important to you and hit on those. If you've got 12 issues, you can't argue 12 issues in 10 minutes. So pick out the ones, be ready to deal with any of them. I can always remember when I was at the AG's office, walking in and to argue my case in front of the Court of Appeals, and I barely got my name out, and Judge Severs said, "Mr. Arterburn, we know who you are. We've got questions." And you know, that kind of stuff, you know, hopefully we're quite that terse with you, but you're going to get questions. And so you got to be ready to deal with all parts of your case. But, you know, pick out the top 2 or 3, say, I'm prepared to answer any questions about any of the issues, but here's where I want to concentrate today, and then go forward. So as far as COVID issues with the appellate courts, at least as of when I left my office this at noon, we are still on for live arguments. And the court is, even when we are hopefully totally in a post-COVID world, we are going to entertain motions at times by people who do not want to appear personally for whatever reason. For oral arguments, we have definitely seen that we can do them by way of WebEx, and we can have one person there live, and we can have a person there remote. My preference is to have people there live. I will tell you that. I think that it's more effective to be there live, but I know there's reasons not. And frankly, one of the big reasons that we're going to provide more latitude is for the lawyers from out west. It really doesn't make sense to make 2 lawyers from Scottsbluff drive all the way to Lincoln to argue cases for 10 minutes and go home. And so that we haven't adopted any formal rules on that, but it is a motion you can make if there is a strong reason. Now, I'm going to tell you, since driving from Omaha to Lincoln, distance is probably not going to be a good reason. I'll put it that way. Now, if you got a case that's being heard remotely, because the Court of Appeals, we make sure we have arguments in all 6 districts of the state. So if you had a case that was in North Platte and our arguments are in North Platte, you might have a shot, but we also might say, well, you tried the case in North Platte. So, you know, and then the other problem is when we are remote, our technology abilities are, depending on where we are a little bit more limited, depending on where we are. When we're at Wayne State College in September, we're having them there so students and so forth can see. So we're not likely to let people off the hook there. We try to schedule cases from that part of the state when we're in those other parts of the state, but it doesn't always work out that way. So that's really all I have. Any questions? Okay.
One thing, thank you so much. First of all, great news. Everybody won the lottery. You get 15 more minutes because we went over. So congratulations for sticking around. You get an extra 15 minutes. Again, thank you all for being here today. Really do appreciate it. We're going to put notes together, make sure that we're not misrepresenting anything that you said, and edit so everybody can download that next week. In case you didn't take notes today, we'll put it up online. So thank you, everybody.